Chevron deference is dead. So for years, the circuits were deferring to the reasonable interpretations of the board on ambiguous phrases, like what is a crime involving moral turpitude, for example, right? Now there's no more Chevron deference. So what do you do to all of these cases, all of this precedent that had relied on Chevron deference, where Chief Justice Roberts is saying that was unconstitutional from the start? There is a throwaway line, in my opinion, from Loper Bright, where the Supreme Court says our prior precedent is subject to stare decisis, so we're not overruling all of our prior precedent just because it relied on Chevron deference. Now, to me, reasonably, that seemed more focused on the Supreme Court's prior precedent, not the circuits, because a fundamental change in law like Loper Bright, for that to not overturn other stuff, that's wild to me. Like, for example, Dobbs overturns a lot of things at the circuits because it's a fundamental change in law on abortion, and there are other cases like that. Same with Bruin and guns. But the circuits have been using that line to say our prior precedent remains, notwithstanding Loper Bright. You follow? But it hasn't really been fleshed out. And here the Ninth Circuit is fleshing it out a lot more. Here the Ninth Circuit said, okay, if we've set a crime as a CIMT in the past, California theft, California fraud, for example, we can't overturn that as one panel just because of Loper Bright, because of that sentence. But quote, let me get the quote because it's important. I did this before too. I can't get the actual quote, but what they said in Murillo-Chavez v. Bondi is that the framework that was relied on to get to that's not due stare decisis, because the framework, Chevron, has been overruled. So maybe to get there, to determine that this California fraud crime is a CIMT, they used a certain framework on what is a CIMT and Chevron deference. But now when a similar Arizona fraud crime comes before the Ninth Circuit, they are not bound by that prior Ninth Circuit decision saying that a very similar California one is. And that's an important thing, because to me that gets to the argument I want to be making. If the Ninth Circuit's CIMT definition, for example, is based on Chevron deference, I think we should be attacking that CIMT definition. Or with particular serious crimes, or particular social groups, or so much with employment law. What is a manager for L visas? All these things that are ambiguous. Even if there's a prior decision from the circuit relying on Chevron deference, I think it should be attacked. And here's the Ninth Circuit saying that analytical framework, that might be subject to re-review. Now, with CIMTs, the Ninth Circuit says there's very little daylight between us and the BIA. So, what is a CIMT? We don't really need to relitigate it. But that might not be the case in other contexts. I mean, why is a particular social group made out of immutability, particularity, and social distinction? BIA just made it up. And I'm almost positive that every circuit that's ever reviewed MEVG and WGR, those seminal Ninth Circuit decisions in matter of Acosta, have relied on Chevron deference. They're not doing that on their own. That's pretty wild.